Home Affairs Minister Dr. Aaron Motsoaledi has announced changes to the country's amended immigration regulations. It affects general remote work and critical skills visas. The current application system has come under criticism from the long delays in issuing foreign work. The minister tabled the amendment to the Immigration Act to deal with the arrest of foreign nationals as well in response to the two Constitutional Court judgments. To unpack the purpose of this bill, we are now joined by the Minister of Home Affairs, Dr. Aaron Motsoaledi. Minister, good morning. Thank you so much for making time for us. Let's start here. The response to the Constitutional Court judgment and the amendments that are now being made in around, for instance, the arrest of people who are suspected to be in the country undocumented.
Good morning, Aldrin. Good morning to the listeners and viewers. Aldrin, let's get clear which are we talking about, which bill. Are you talking about the bill on the Immigration Act?
Yes,
or are you talking about the new policy?
Yeah, we'll start with the bill on the Immigration Act, and then after that we'll deal with the issues around the visas regulations and changes to that. So let's start with that bill.
Yes, thank you very much, Aldrin. Yes, you will be aware that this is a long-standing matter. In 2016, the High Court in Pretoria declared Section 34 of the Immigration Act unconstitutional. As you know, in terms of the law, once a court has declared a bill or an act or a part of it unconstitutional, it must be confirmed by the Constitutional Court. The Constitutional Court confirmed it in 2017 and gave Parliament 24 months to rectify the problem. Unfortunately, that did not happen, and as you know, there was a ruling in the Constitutional Court in October last year. So what we have done was to develop the bill in terms of the instructions of the Constitutional Court, because they even did something that we call a write-in, whereby they actually gave us the weight that must appear in the bill. We have done so and handed it over to Parliament. Basically, it is about arresting a person who is illegal in the country and how to start the process of deporting them, sending them to Lindela and deporting them. The part that was declared unconstitutional was having two main problems. There were many, but two main ones. That you could arrest without a warrant, and that after arresting, the person doesn't have to appear in court. They'll go to court if they ask to be taken to court, but if they don't, you don't take them to court. And the court said, no, it can't be. It has to be automatic that somebody who is arrested appear in court. And secondly, they were worried about the issue of warrant. So what the Constitutional Court has done, they've introduced a new but very difficult principle called in the interest of justice, meaning when a person is found illegal in the country, the immigration officers have to determine whether it's in the interest of justice to release that person or not. And then if he has decided that it's in the interest of justice to arrest him, they do so. But when the person appears in court, the magistrate must also determine whether it's in the interest of justice to keep that person or release them. It's a very difficult concept, but be that as it may, we've sent the bill to Parliament and it's in their hands now.
Yeah. So what does that then mean from your perspective around the implementation of that wording that the Constitutional Court has brought in?
We have put the wording in the bill and sent it to Parliament. It's up to Parliament to decide. But on our side, we have workshopped our immigration officers, because the main issue here is the issue of determining what is in the interest of justice and what's not.
Yeah. Does this at all, Minister, make it a bit difficult for you also to deal with this issue around immigration, considering that we're still waiting for the Immigration Board to be appointed?
Well, it makes it difficult for immigration officers because they need to get a clearer understanding. They need to have a clear mind to determine what is in the interest of justice or not. That also applies to magistrates, but they are better than immigration officers because at least they are legally trained. But that is the central issue. You have got to determine in arresting this person. But the good thing, Aldrin, let me not also mention only the most difficult thing. The good thing is that if you decide that it's not in the interest of justice to keep that person in jail while you are investigating their issues. You must put conditions under which they are released. I think that's a good thing. It's like bail, whereby you say we are releasing you on bail, but here are the strict conditions. You are to report 3 times a day. You are to hand in your passport. You are not supposed to go to this and that, So the immigration officers is given power to release that person if they have reached a conclusion that it's not in the interest of justice to keep them, but they must release them with conditions.
Yep.
And the conditions, fortunately, must be determined by the immigration officer in their own discretion.
Well, Minister, the Constitutional Court was also quite scathing on the conduct of the minister as well as the DG, going as far as saying that lastly, there's not even the remotest hint of an apology by the minister and the Director General in their papers for the deplorable state of affairs in this particular matter. Of course, and this is speaking around the delay. And I know that Minister has responded to this particular part around Minister also being held liable and personal costs being imposed on the Minister. Has any action, Minister, been taken against the DG?
Well, that's an internal matter.
Sure, but has any action been taken against the DG?
I'm saying that's an internal matter. I will report it when the time comes. But let me also correct a little bit, because it's not exactly what you said. The judges wrote me a letter to explain why I should not be charged personal cost, and I wrote a very long affidavit. After that, the judges, when they made the final judgment, they said it's clear that the minister did not do anything wrong here because he did not know personally. But then they said, because the minister is responsible for the conduct of his officials in the department, then he also becomes liable. Not that I was guilty of anything. It was just that I'm taking responsibility. And this matter is discussed in cabinet about the extent to which ministers are required to take responsibility for the conduct of officials working under them, when in other areas where it said that we must not interfere with administration of the department. So it's a sort of a conundrum which is still being discussed. But that's what was the ruling, because I was not found to be guilty of anything except the fact that I'm responsible for the conduct of my officials.
Okay, so the conduct of one of those officials being the DG, you say it is an internal matter. What does that mean?
It means that I am not here. I can't here to explain exactly what is that which you are doing. I'm not yet ready to do that.
But does that mean that you do intend taking action against the DG?
Aldrin, honestly, are you not stretching it too far? If there is anything I'm doing, I'll come to you and inform you at the right time. If there's anything, if we haven't done anything, I'll also do the same.
Yeah, well, Minister, as a public servant, that's the reason that I'm asking you this question as well, because it has implications as well that you have a DG who, amongst others, also, as the Minister had said, had gone ahead with an application without your knowledge.
Yes, I do agree, Aldrin, but everything happening in the public service also, even if it's the public service, is reported at an appropriate time.
So are you taking any steps? That's the only thing that okay, let me ask you this way, Minister. What does this matter is an internal matter mean? What does that entail? Without saying whether you will be subjecting the DG to a disciplinary action.
The question is the same, Aldrin, please. You are stretching it very far. You have asked me if I'm taking any action. I'll announce at the appropriate time whether action has been taken or not. For now, can't we just leave it there, please? Even if matters happen in the public service, they are reported at the appropriate time. It's like in the institution where you are working. You are having background meetings to agree on what you must do and not, and announce it to the public. But you do it at an appropriate time. You don't just do it any time.
Okay. Let's then speak, Minister, about the visa regulations. You also said there yesterday during the press briefing that you were ill-advised. What happened?
No. It was the issue which looks small but can be significant depending on how you look at it. It was the fact that there was a closing date for public comments. but the public comments were given unduly long time, 60 days. We usually give the public 30 days when we are changing regulations, but this time it was given 60 days. And then the officials thought it was long enough, and they gazetted it the day before the closing date. And so it's procedurally wrong, and I'm saying, look, we need to correct that and make sure that because people who might have given inputs, they can come and argue that, no, I was going to do it just the day before the closing date, and I was not given that opportunity. That is exactly what I was trying to explain.
Yeah. So does this mean that you're not necessarily saying that there will be any changes to what has been published? It's just an issue around procedure and allowing enough time for the public to comment. But the text itself still remains the same.
No, not necessarily. There might be small changes.
So what are some of the small changes?
Well, some of the mistakes we've picked up, like, for instance, on the point system, there is something about a person having to show that they've got easy adaptability to the country. And we found it a little bit vague. We are going to tweak it. But the other changes that may happen will be for the public comments that came the day just before the closing date was done, because that day was cut off, and we believe it's also significant. There might be some significant inputs on there, so there might be changes.
Okay.
What we are going to do.
Do you have any idea, Minister, how soon you'll publish the new proposals?
Yeah, well, last week in the press conference, yesterday rather, in the press conference, I said we are looking at next week, but it might take a little bit longer, because when we read the bill again, we found that there might be some bit of complexity. But we want to do it as soon as possible. But yesterday, I promised a week's time. We'll see what happens.
Okay, thank you so much for your time. That is the Minister of Home Affairs, Dr. Aaron Motsoaledi.